Hey, what's going on, everybody? Welcome back to Man Views, where I cover videos that can possibly help our fathers and men. I'm B, the CEO, and let's get to it.
We're under an active tornado warning right now. We just had the sirens go off for like 10 minutes. So if I have to run, you'll know
Okay,
why.
that's fine. If you have to go, then just run and we'll know what's happening.
Okay. So, fair warning.
We are on the record for case 2015-1447DS, Alexis Tabaka versus Christopher Tabaka. It is Wednesday, April 17, 2024 at 2:01 p.m. Attorney Elaine for defendant.
Good afternoon to everyone.
Good afternoon.
This is the time and place set for the court's ruling from the hearing on April 9, 2024. Court will note that both parties filed motions to show cause for violation of the court orders of 11/3/2015 and 9/25/2023. The court has considered all of the testimony evidence and given the appropriate weight to that. In these cases, credibility is always a consideration. Oftentimes, a party will allege that the other party or one of their witnesses is not truthful or has lied. The court has found, however, that inconsistencies in testimony does not mean that an individual has lied. Conflicting testimony can occur as a result of the witness's background, perception, bias, understanding, misunderstanding, or mistake. When inconsistencies occur, the court will attempt to determine if the inconsistencies can be reconciled by other testimony or evidence. There was some inconsistency in this matter, but not to the extent that the court would normally see. In that regard, the court will note that Ms. Goldstein, the plaintiff's mother, did testify in this matter. And when she was asked about walking, when Madeline was walked from school to her piano lessons, she stated in answer, it was made clear that Chris walks Madeline to piano lessons. Miss Elaine asked, how was it made clear? And I'm saying this because I did review I reviewed the testimony in this matter. Miss Elaine asked, how was it made clear? She said, it was brought up earlier in his testimony. So Miss Elaine then asked, so you listened to his testimony? She said, no, plaintiff said it when she asked me a question. I reviewed all of the testimony of the examination of Miss Goldstein by the plaintiff, and the only place that was referenced to any statements the defendant made was when she was questioned, was defendant accurate when he was claiming he was denied time? And I don't, obviously in this case, I don't want to ascribe any violations by Ms. Goldstein of the sequestration order, but I know that I know she's been intimately involved in this case, so she could have had another explanation for how she got this information. But taking her at her word when she said it was brought up earlier in his testimony does make the matter suspect. And as a result, to eliminate any possibility that the sequestration order was violated and that Ms. Goldstein's testimony impact on the case, the court is going to strike her testimony. I would note in doing so that her testimony was of nominal value to the issues before the court. As a result, to eliminate
the chairman of the full committee,
we're getting feedback. So at issue in this case, and the court will note, is the order for custody support, parenting time, and preschool daycare dated November 13, 2015, which provides that plaintiff would have physical custody, the parties would share joint legal custody, and defendant would have various parenting time. At issue in this order is paragraph 4 contained in the joint legal custody paragraph, which provides, and I quote, it is further ordered in a judge that as a joint legal custodian, each parent will advise the other promptly of any illness, injury, emergency, or other significant event concerning the children, and then parentheses, including school or health problems, if any, and brackets, which the parent becomes aware, end quote. Plaintiff complained that defendant held the children out of school on February 8, 2024, because they had fevers, coughs, stuffy nose, and no energy. Defendant states that he withheld the children from school in response to a notice from the school principal advising parents to hold kids out if they experienced any flu-like symptoms. Plaintiff testified that she received defendant's Exhibit N, which was the Our Family Wizard message on 2/8/2024 at 3:12 p.m. stating that defendant had kept the children out of school the entire day due to coughing, stuffy nose, fever. He testified that the children were bored. The Our Family Wizard message, as did defendant's testimony, confirms that the children slept most of the morning and, quote, seemed better this afternoon, end quote. Defendant testified that the children felt much better in the afternoon, and Madeline went to an art class and Daniel went to tennis. Plaintiff testified that when the children came back to her at 7 p.m., that the children exhibited no flu-like symptoms. The court finds no fault with the defendant keeping the children out of school. This is a routine practice exercised by parents, probably each and every day for children. Each time sometimes these decisions are borne out, sometimes they are not. Defendant then removed the children from school on February 9, 2024 at noon for a surprise trip to Kentucky. Defendant never notified plaintiff of removing the children from school on 2/9/2024 at noon. Plaintiff testified she first found out about the children being removed from school and the trip on Sunday when the children returned to her. Again, the court finds no fault with Mr. Tabaka removing the children from school on a limited basis to take them on a vacation. This happens oftentimes by parents. The issue, however, is whether the defendant violated the November 3rd, 2015 order by not advising the other parent promptly of any illness, injury, emergency, or other significant event concerning the children, if any, which the parent becomes aware. I should preface my remarks by noting that this case has been extremely contentious and perhaps one of the most litigious cases that this court has had based on the voluminous pleadings filed and the hearings that have been held. Defense counsel argues that defendant's notice at 3:12 p.m. on 2/8/2024 was promptly given. Webster's dictionary defines prompt as on time, punctual, or done without delay. When the notice given on 3:12 p.m., approximately 7 hours after the children were taken out of school, was done without delay. The court believes that notice approximately 7 hours after an event, especially given the history in this case, was not promptly given. Counsel argues that paragraph 4 applies only to significant event and therefore it is not applicable. Paragraph 4, however, is a disjunctive sentence and each event stands alone. This sentence means that a parent must advise the other parent promptly of any illness, injury, emergency, or other significant event concerning the children in school, and health problems, if any. Other significant event does not qualify as any other circumstances listed in paragraph 4. The court finds that defendant, in noting that he did not notify her at all on the having taken him out on on 2/9 2024. The court finds that defendant did violate the order of 11/3/2015 and is in contempt of court. Defendant filed a motion to hold plaintiff in contempt of court for failing to provide parenting time as delineated under the order of 11/3/2015. The court is not going to reiterate the basis for the motion as it was previously litigated and concluded with plaintiff being held in contempt of court by order of 9/25/2023. The earlier action was tried on 3/7/23, 3/28/23, and 5/12/23, involving other dates that parenting time was denied. The court does not know the reason that the dates in the present claimed violation from 11/9/2022 through 5/19/2023 were not included in the prior proceedings. At the motion hearing, when defendant raised the present violations in October of 2022, the court informed the parties that the court would not address matters occurring prior to the order of 9/25/2023. The intent of the 9/25/2023 order was to hold plaintiff in contempt for all of the violations that occurred prior to the order. To hold plaintiff in contempt for each and every denial of parenting time would not only be redundant, duplicative, and would not serve any purpose. The court will hold that violations of parenting time at issue with the current motion were covered by the prior contempt finding. The intent of the order was to clarify and impose conditions on parenting time, hopefully to eliminate any future violations. Clarification apparently had its desired result, as there have not been any violations of parenting time following entry of the 9/25/2023 order. Plaintiff's Exhibit A reflects violations from 11/9/22 through 5/19/2023. The last two entries are dated 5/16/2023 and 5/19/2023, which post-date the last hearing on 5/12/2023. There is in the law a doctrine referred to as res judicata. The doctrine provides that a party may not raise issues that were heard in a prior action or those matters which could have been heard. But for this doctrine, the parties would be able to continually litigate every issue they desired over and over, or bring up every minute issue time and time again. The court will hold that the doctrine of res judicata bars all action for all parenting time violations prior to the date of the hearing on May 12th, 2023, as provided in the last evidentiary hearing. Therefore, we are left with two violations from 5/16/23 and 5/19/23, which were violations of parenting time for 1 hour each. The court, as a result, will permit the defendant 2 hours of make-up parenting time for these two missed parenting time. The court previously ruled that this provision does not apply to periods of 1 hour or less before school. And to address that point, I want to, Ms. Elaine had contacted our office concerning the order entered on on September 25, 2023, stating that she believed the wrong order, that Mr. Schaefer's order had been entered. I'm looking to the order that we have in the file, Ms. Elaine, and it is your order, which states under paragraph 2 that you had questioned the provision does not apply to periods of 1 hour or less before school.
That's
As a
weird.
result, I don't know if Mr. Schaefer's order somehow got entered as well, but I note that the order that we have was your order and not Mr. Schaefer's order.
Okay, thank you for that clarification. That's good news. The one I was sent was the other one, so.
Okay, I don't know how that happened
Okay.
but the one that's in the court file that we have was your order.
Perfect, thank you.
In this matter, the reason the court had excluded the 1 hour before school was because of the transportation, and that, in fact, the transportation of the children would take approximately, would be a little less than an hour. And so the court felt that it was not appropriate to, in fact, utilize those times of an hour because the children would simply be in transportation to and from the plaintiff's home. The court, as a result, is going to expand, if you would, that 1 hour time frame to the time after school as well. The court's ordering of the makeup parenting time of 2 hours will be subject to the same conditions as set forth in the 9/25/2023 order. The order from the present action heard on 4/9/2024 will apply to all contempt actions by either party occurring before 4/9/2024. So the court will not entertain any other motions for contempt prior to that hearing. There was a request for attorney fees. The court will note that the plaintiff prevailed on her motion. Defendant prevailed nominally on his motion. Plaintiff did incur attorney fees prior to her attorney withdrawing on February 22nd, 2024, and defendant incurred attorney fees as well. The court will offset these attorney fees and not award attorney fees to either party in this action. Ms. Elaine, I will ask that you would prepare an order as to the 2 hours of makeup parenting time and denying attorney fees under MCR 2.602 parens B parens 3. And Ms. Tabaka, you can prepare an order which would hold defendant in contempt and expanding the 1 hour to the after school as well, and submit it under the 7-day notice. Court would note if either of the parties desire their exhibits returned, they can pick those up within 10 days of today's date, and if not picked up within that time, they will be disposed of. With that, I'll ask Ms. Tabaka, is there anything else that you believe the court has not addressed or needs to address before we conclude?
No, sir, I think that was very thorough. Thank you.
Okay. Ms. Elaine, is there anything you believe I need to address or have not addressed before we conclude?
Your Honor, if you could just clarify the way that you assigned the order drafting, and then if I might suggest that I prepare one order and send a draft of that to Ms. Tabaka to agree to, instead of both of us submitting something under 7-day with the possibility of having objections.
That would be fine. I didn't want you to be required to, in fact, prepare Ms. Tabaka's order because you don't represent her, and I didn't want her to have to prepare yours. But my intent was originally to have one order prepared. It would be much simpler, more direct. And to go over that again is the court would order that there would be an order for 2 hours of makeup parenting time under the same conditions as the September 2023 order, meaning they can't be held on the holidays and things of that nature, and that it would hold the defendant in contempt of court, expand the 1 hour time frame contained in paragraph 2 on the second page of that order, where it says, and I quote, "This provision does not apply to periods of 1 hour or less before school," and I would expand that to after school as well. And I think that is addresses all of those points.
Your Honor, I do have a question about the 1 hour time, because if you recall from the hearing, that was an average because the children get out of school at different times. So
I
for-
understand.
Right, but I'm just, if you're going to impose the 1 hour limit for after school, how will that work when Madeline's time is, if it's an hour and a half? Should he just focus on that hour and a half and then not the lesser amount of time for Daniel?
You mean
Because
if
that's
if
what
it's in fact denied?
I'm sorry, go ahead. I
You
didn't
mean
hear
if
you.
in fact it's denied in the
Right.
future?
Right.
Well, what I would do is I would not, because I'm not going to take into consideration the 1 hour. So obviously you'd be talking about a half an hour time if in fact there's a denial in the future. And the court would consider that.
All right, so we might just have instances where there's a violation as to one child, but not both, is
You
what I'm
might,
saying.
might have that. I don't
Okay.
know.
All right.
Okay? With that, the court will close the record. You're free to go. Have a good day.
Thank
Thank
you.
you, Your Honor.
With that being said, as always, don't forget to like the video, share the video, and comment your thoughts below. Let's start a dialogue about this topic. As always, subscribe to the channel. See you next time, man. Peace out.